This conference will now be recorded.
Gavin, should we get started?
Yeah, let's go ahead and get started. I know we're kind of started. One second. I need to mute myself. We're going to start right on time because we do have a lot to get through. So I'll go ahead and start calling the roll. And I'm sure
Great.
there's quite a number of people that will be arriving after the roll is called, but we'll just add them as they come into the conversation. Kent Barnett.
Hello.
Thank you. Yeah, if you could just say hello so we know that your microphone works. Jack Bierman. Eric Benderson. Michael Cole.
Yeah.
Anika Cooper. David Engstrom. Looks like you just signed on. You're muted, but I think.
Yep, I'm present.
Great, thank you. Hi Feldblum. Janice Hoffman.
Yes, I'm here, thanks. I'm here, thanks.
Thank you. Renee Landers. Jeff Lubbers. If you could go ahead and mute your microphone if you're not speaking. Alexander Emanuel. Thomas McCarthy. David Pang, serving as alternate for Patrick Nagel.
Here.
Thank you. Roxanne Rothschild. Chris Walker. And Russell Wheeler. I believe I saw Russ.
I'm here.
Great, thank you. And then on ACUS, but not in the Committee on Adjudication, William Funk. And serving as an alternate for the DOT member, Joe Solomon.
I'm here. Thank you.
Great, thank you. So I think that's it.
Gavin, I see Tom McCarthy is here and also Judge Manuel and Chris Walker.
Great. Thank you all and welcome.
Okay, we're going to get started. Yeah, thank you. We're going to try to be very efficient today, so I'm going to run through the ground rules as quickly as I can. Many of you are already familiar with those. Obviously, to avoid background noise, we're all well versed in this. Keep your microphone on mute, and you can either raise your hand or add a comment in the chat feature if you'd like to speak. We will then make sure that you have that opportunity. Please use the webcam if you can. It allows me to see you and call on you. It helps with cues and the process much better if I can see you. Also, ACUS members will be given priority in speaking. Members of the public, I suggest, I ask that you use the chat feature to indicate when you'd like to speak. I will allow you that opportunity at the right time and appropriate moment, and then you will be unmuted. Recall, as last time, using the chat for substantive discussions is not allowed. Please just keep your substance to the conversation and the discussion. It's much better that way, and not adding it to the chat. Use the chat only if you want to speak. We will take a vote at the end of today's meeting. We are hoping to wrap up before 3, if at all possible. In fact, it has to happen before 3. Only members of the committee have a vote. Please do not vote unless you are a member of the committee. If you're not sure, we have a list. Last point is to note, as I said at our first meeting on this project, ACUS Vice Chair Matt Weiner and committee member Chris Walker are not participating in any capacity in this discussion in this meeting, other than as co-project consultants, 2 roles that they have ably met and demonstrated here for us today. So without further ado, let us get to the work at hand and I would like to turn first to the recommendations that we covered already. I think we can dispense with these fairly quickly before turning to the recommendations that we have not yet discussed. So let's look at 1. Anything on 1? Three. Well, you guys are really, this is great. 4.
I'm sorry, did you mention 2?
Thought I did, but maybe I didn't. I'm just so
All right.
excited to go quickly here. This is great.
Right. There is a change in paragraph 2. I just wanted to note the change that had been made
Okay, sure.
for consistency of language. And then we can move on if nobody had objections to that change.
I'm not seeing anybody, so that's great. Okay. 3, I think we said 3 and 4. 5. 6, there were a few edits there, but I think mostly stylistic. 7.
There was a comment that was submitted about clarifying whether review here is intended as interlocutory review or post-decisional review, or both, possibly.
I think we talked about the referral of cases. They would be interlocutory if I'm recalling that correctly. I'm looking to Judge Manuel. I'm not sure if we discussed it, if that was a point that he raised. Sorry to put you on the spot, but for some reason, you're coming to mind on this point. If not, tell me otherwise.
No, as I recall, there was a brief discussion on that. We were trying to differentiate and show the distinction between the 2 types of appeals. But there was sort of a general mention of it. I don't know how much detail we want to go into on that.
If we leave it as review, is it clear that we could possibly mean both? Do we need to be specific there? I'm trying to think of a situation where a hearing level adjudicator would be referring a case or an issue for review. I'm familiar only with issue. Judge McCarthy.
Our hearing officer, our ALJs refer certified cases for interlocutory review to the commission. And I believe a few other administrative agencies do that. So I think that's what that is in reference to.
Okay. Let's add interlocutory then. Okay. Anything further on that one? Thank you for flagging that, Gavin. I'm trying to move quick. All right. Recommendation 8, paragraph 8. This is where we start to get into some more of the edits that were discussed at the last meeting, and we had referred some of the language subsequent to 8 to our esteemed consultants. So let's look at 8. Anything on 8? Okay, 9.
This is Jeff. Sorry, I joined a little late. I just have a question about 9 and 10. Those designed more for high volume situations, because it doesn't really seem to be that pertinent to review bodies that don't have very many cases.
I think that's probably true. And I'm not sure if we wanted to add any specific language to make that clear there. I see Russell had a comment. Russell, does that relate to what you were going to suggest?
Well, it goes beyond that. It seems to me, though, that the phrase "in an appropriate default docking method," the word "appropriate" seems to me to cover Jeff's main point. But my concern is broader. I don't know why. I realize I see the staff knows why we eliminated the word screening, but that's the common term for what we're talking about here. And it seems to me the recommendation may also want to convey that the screening, when it's done, is done by staff, but under criteria established by the adjudicators. One not knowing that would read this and think it's for the adjudicators themselves to spend time grouping appeals. My experience, admittedly in the judicial rather than the agency context, is that staff do the screening, but they do it according to criteria established by the, in this case, the judges. There's probably more detail than you want to go to just in the recommendation, but I think this, as worded, could give a rather misleading impression of what is likely to happen in agencies that decide to use some sort of screening method.
I think there was discussion at the last meeting about using the term screening, and perhaps describing it was an easier way. It's not a term I'm familiar with in my work at an appellate system, adjudicatory system. And so I think the idea was to describe it to the extent that it doesn't specify who would do it. I can only speak from my own experience. I'm not sure that it would be staff that would be doing this as opposed to the chief or head judge of our agency that would be looking for ways to streamline how cases are assigned, and whether that would be delegated to attorneys to do or some other sort of staff. Trying to think of how it might be analogous to an administrative agency situation. Judge Manuel, do you have a comment on that? I see you're unmuted.
Yeah, because I thought that we were trying to address last time the issue of screening and sort of making exceptions for certain cases where you certainly want kind of I think most agencies use the approach kind of a random assignment of cases to judges. You're describing here certain situations where you want to take other factors into consideration, such as the types of case and perhaps processing certain kinds of cases more quickly and that sort of thing. So that's kind of the dichotomy to consider, screening systems, yes, but that there should be sort of some exceptions, or there could be, depending on the needs of the agency, to use a methodology other than just sort of a random screening. So that's what I was trying to get at here. Or I was trying to consider other language that would perhaps make that more clear here.
Do you have any concerns with the language that's there now?
No,
Okay.
I encompasses that, yeah.
Okay.
I just wanted to add one thing. The old 10 did talk about the use of staff attorneys and law clerks at both stages. You kind of substituted robots for people in our new 10. But anyway, if we wanted to say something about using staff attorneys and law clerks, we could import it into 9.
Yeah, I think there's a spot there that we could include it on in the sentence where we explain what the benefits are, of the potential benefits are of following a system like this.
Or we could put something in the preamble.
I think it would be easy enough to add on the line where we say that the potential benefits such as reduced case processing and efficient use of, that's one of the benefits of doing this, presumably. Or Matt, I'm trying to see Matt and Chris, to the extent that they looked at this in the report, if they have some thoughts to add on this.
I think you could add, I agree with what you just said. You could just add use of staff attorneys and law clerks in that list of the benefit.
I had a thought that, I mean, I wasn't sure, is default the best term to use there? I know part of the concern was making sure that that's typically the way most agencies will handle it. It's not always the only way, I suppose, but Judge McCarthy, I see you're unmuted. Did you have something?
Well, I had a couple of thoughts. I mean, I'm thinking of the National Labor Relations Board. It's the executive secretary that kind of assigns the panel of board members. I don't know how it works at Osherick where you are, Nadine, although I know you have simplified proceeding rules, which would fit nicely within, I think, what's contemplated here. We got rid of our simplified proceeding rules, but our docket office would assign cases to panels of adjudicators. So I don't know if the work is actually going to be done by line attorneys or staff as opposed to a centralized docketing system. So that's my thought.
Yeah, I guess I like the idea. I know Russell's looking for a little more certainty there or clarity, and I like the idea of leaving it for the agencies to determine how they'll implement it. I think the idea of the recommendation is really to just get agencies to think about using this sort of system within their assignment process.
Nadine, what if you just said it on the first line is typically an appropriate docketing method, although blah, 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 and then get rid of the word default. So it's typically an appropriate docketing method.
I like that. I don't think you need the A, Gavin, is typically. Yeah.
So
Roxanne, I hear your voice.
just to speak to Judge McCarthy's comments about the NLRB and what the ES office does, that would be my office. I think that this paragraph or this number 9, the way it's stated, pretty accurately describes what we do. We have a default randomized assignment method for docketing, but we do try to, whenever it makes sense, group and sort and assign differently to make the most out of everyone's, I'd say not just skills, but time. So more efficient use of adjudicators, staff attorneys, and law clerks' skills and time. But I mean, not that that's a big deal to say that as well. But otherwise, I think it's a pretty accurate statement of how we do things and how we try to make sure we're being as efficient as possible.
I think that's good. I see Russell raising his hand. Russell, you're muted.
I don't want to beat a dead horse here, but it seems to me there's two kinds of random assignment. One is just assigning cases without regard to their characteristics to adjudicators. The other is making sure that cases don't get assigned to specific adjudicators based on whatever criteria that may exist, either skill or policy preference. And so there's random assignment has two different things. And the recommendation, I don't think wants to leave the impression that we're abandoning, I think anyway, the notion that cases should not be assigned to adjudicators based on anything other than neutral criteria. I think this, in some ways, this paragraph is gotten more complicated than it needs to be, and that may be my fault, and so I apologize for it. But there's a lot of conflicting attentions going on here. Why one screens or groups, however you want to say it, and it's not so much a case assignment system as it is a way of grouping cases for decision. But I probably said too much.
I don't think you said too much. I mean, I think our goal here was to try to explain how an agency could use some of these factors to streamline their assignments. I guess I would echo what Roxanne is saying, that, I imagine that for the most part, it's a random assignment of cases based on, as you're saying, neutral factors. To the extent that there's ways to take into account complexity of a case, the size of a case, and target cases in a way so that they're more efficiently processed and decided. I imagine that might go on without having to be said, but to the extent there are schemes that don't take this into account, particularly for high volume agencies, as I think Jeff pointed out. Is there any specific language that could be proposed here that might allay any concerns?
Well, if I could just say one more thing to say why I think the language is appropriate the way it is, I think that even saying that you're using these other criteria doesn't mean you lose the randomness. For example, we have a standard case docketing list that we randomly assign to the different panels and offices, but we have a separate docketing list for what we call long record cases. And those then get randomly assigned to different panels and offices. And that way we don't run into a problem where, because of luck of the draw, 1 or 2 offices are getting all of the long record cases and they're getting bogged down and not getting to those cases like they should. And so it's still random. It's just another factor that we're using. So I think the way it's stated now works for me and doesn't make it sound like we're telling people to implement something that would be non-neutral and inappropriate.
Okay.
Judge McCarthy, I see you raising your hand.
I just wanted to ask Roxanne if this recommendation accounts for what used to exist at the NLRB, the system of icing particular cases that are lead adjudicative cases, and other cases kind of are grouped or sorted under that ICE case to be decided after that case is published. And whether the committee can address that.
I think this covers that because it's subject matter, the part that says subject matter of a case. We do at times have what we call a lead case that is going to issue, and then there's a bunch of other cases that raise the same or similar issue that have to wait for that lead case to issue. And so yes, that's where we group them by subject matter, and but we get them queued up so they're ready to go once that case can go. So that is one of the, I think this covers that.
Okay, thank you.
One final question. Would need for oral argument be one of the criteria?
I think it might. I don't know if that's something that came up in Chris and Matt's consideration in the report. I don't recall.
I don't think it did.
I think that need for oral argument would come into play in terms of the scheduling of the work on a case, but I don't know, I'm trying to think how that would come into play for the assignment of the case.
Okay.
Not sure. It might, maybe I'm just not being flexible enough with my thinking, but I don't know that that would come into play for assignment, at least for us.
Any thoughts about adding that? Judge McCarthy, are you unmuted?
I am unmuted. I think maybe if we add that, we should add it in recommendation 14, which talks about the value of oral argument. I know that my agency has oral argument on, I think, every case that they hear. Much different than the procedure that I recall at the NLRB.
So we should leave that language out here and think about it for there.
That would be my thought.
Any other thoughts on that? Okay, and we can leave to committee on style the addition of the language that's in bold. I see now. You got that, Gavin, I know.
Yeah.
Okay, great. Okay. Let's move on. The staff attorney, 10, we've included now staff attorneys, and 9, let's see, new 10, is the artificial intelligence one. So we have a recommendation here from the staff at the conference regarding the fact that we have AI projects in play. And let's see, 2 pending projects.
That's right.
I think I mean, I don't know if you want to speak to that, Gavin. I think it speaks for itself. I think I don't see any reason to not leave this out here and leave that to the better projects that are best suited to addressing it. It's certainly not something on the horizon at my agency, but we are just one place. So my suggestion would be that it come out along with the recommendation, following the recommendation of the conference. Does anybody have any thoughts on that? Jeff?
I will clarify, it's simply my recommendation as a staff attorney for the committee, and it isn't a recommendation of the conference at all.
Okay.
Well,
so
I meant it's merely my suggestion that the committee take into account.
It's a wise suggestion, Gavin. Jeff, you had a comment?
No, I just agree. I mean, I think unless we can give agencies a little bit more pointers on how to do it, it's not going to be, acted on.
So you disagree you would include it?
No, I would take it out.
Okay. All right. I misheard you. Sorry. Well, let's take it out.
I don't know what Chris thinks. I think under the circumstances, it's probably best to take it out. The AI, Reeve can elaborate. The AI committee is meeting this afternoon. It's got a very robust recommendation, and this is just, there's nothing we're going to say here that's going to add much or be of much use to agencies. That's my sense.
Great.
Just to add, I actually have a comment on that right above it. In the right side there. It sounds like we just want to get rid of it, but if we were to keep it, I would probably just add it to the end of 9.
Thanks, Chris. I'm sorry I didn't point that out earlier.
It was definitely featured somewhat prominently by a few different agencies, that it's something they're either already doing or that they're exploring as a way to kind of sort and group cases. But I mean, whatever the committee wants to do is fine. But I just wanted to flag that was kind of my reaction to it.
Any thoughts? Does that? I think if we're going to strip out mention of AI and machine learning, that maybe we should just leave that be and leave it for the other projects. Any thoughts about that? So we just wouldn't mention it at all throughout. Okay. Let's move on to again number 10, right? It'll be number 10 again.
I guess it's showing as 11.
Okay, that's fine. So we discussed this one last time, and I think there were some concerns about including it, that it really didn't really kind of read as a recommendation, and my inclination would be to strike it. Any thoughts on that?
Gavin, could you open up my comment as well?
This is Bill Funk. I thought originally it said agencies should set their scope and standard of review to be consistent with agency specific objectives, which we mentioned earlier. And I think that still makes sense. That is, people should think about whether or not they should have a de novo standard or non-de novo standard, or how de novo. So the idea of saying that the original first sentence that should set their scope and standard review to be consistent with agency specific objectives, their appellate system, still seems like a good idea to me.
Thank you. I see that now in the comment. I did not recall that, but that's ringing a bell, that the opening line there, that Professor Walker suggested in setting their scope and standard of review to be consistent with the objectives. Is that the language you're referring to, Bill? Yeah, okay. Why don't we we could pull the whole thing over and let's work with it and see what we have.
Gavin, do you, recommendation 83.3, I thought says something on this subject. Am I wrong?
On de novo review, the standard of review,
Correct.
it says delegation is not, while review of right, hold on, I have it open. Agency head should consider the desirability in routine cases of authorizing review authority to decline review in the absence of a reasonable showing that a prejudicial error was committed in the conduct of the proceeding or the decision embodies a finding or conclusion of material fact, et cetera, et cetera. So it goes on to specify a standard of review for a delegated appellate body. And that standard of review is not de novo.
Where is the particular language in 83.3?
It's in paragraph 4A, and what follows.
That goes to the question of whether they should, whether review should be discretionary or not, right? Rather than a standard review, or am I missing something?
I guess that's right.
What I just noticed, what I recall, I'm just looking in the preamble. It says there's a sentence that says this cautions against de novo review, instead favoring more limited review of issues. And I'm trying to see if that's picked up in the recommendation at all. Because that you don't want to do. I mean, what was in the recommendation here might be consistent with 83.3, but in any event, I don't think the committee probably wants to do anything unless it decides it doesn't want to do anything consistently inconsistent with 83.3 unless it makes a conscious decision to do that.
De novo review is not listed or given in the paragraphs themselves.
Okay.
And so, I mean, that to the extent that you have that it doesn't appear in the numbered paragraphs, I mean, I think you could say that it's silent as to whether or not de novo is recommended or not. But again, the preamble does say it.
All right. Well, the preamble is then that's what I was recalling. I have it in front of me now. I find the preamble to be it's not exactly clear what exactly the assembly, the ACUS was saying in 83.3 in the preamble and what its significance is. I mean, the relevant paragraph reads, just for anyone who's interested, efficiency is served by minimizing repetition. The same matter seldom should be put in issue more than once. This cautions against de novo review, instead favoring more limited review of issues properly committed to a subordinate of the agency head.
Well, I guess for the committee to consider, do we want to say anything about de novo review? Good, bad, ugly. I mean, one thought I had was if we retain some of this language is, we simply leave it to the agencies to determine whether or not that standard of review is appropriate under the circumstances. As it stands now, this is drafted as saying don't do it. But it doesn't say why.
If I might suggest making the first sentence end with system and then starting the next sentence in many circumstances. I mean, and I think both the next two sentences are worthwhile because they introduce two different forms of de novo review. One de novo with what you have in your hand, and de novo of adding new evidence. And I think the idea of calling these out as things to consider is entirely appropriate and worthwhile to flag for agencies. It doesn't tell them they shouldn't do it. It just says consider it.
It should consider where the standard of review is not de novo, as opposed to saying should consider whether the appellate model standard of review should be. And so the first sentence isn't a sentence now. I think it's really a question of whether the recommendation we want to discourage, right? That's what this says. Or flag it as a consideration for agencies. And I think we should say why. Is it obvious why this should not be the standard of review?
So just to,
I think there's two different ideas.
Bill, could I ask you to hold your thoughts? So let's let
Yep.
Chris talk. Maybe he can explain it better for me.
yeah, and Matt can, our report details this, quite at length, just how agencies, as I mentioned the last meeting,
Right.
a lot of them have very crushing dockets and huge delays in processing. And one of the reasons why a number of them mentioned was that they review everything de novo and they let all the evidence in that wasn't introduced before the hearing level. And so I think one of the key takeaways, which if you read the 83 report, the report itself actually goes into a lot of detail on this too. It's weird that the recommendation didn't quite go there. Maybe they had a similar discussion we're having right now. But I think this is actually one of the key takeaways from our report is that when agencies figure out what their objectives are, that many of them will adopt more of an appellate review model and not a trial de novo review model, including limiting, the review of certain issues already decided and also limiting the types of evidence that can be introduced on review. And I'll say that appellate systems there's not a uniform approach here on either of those questions. Some review everything de novo, a trial de novo. Some of them, limit like review for abuse of discretion of application of law to facts. On the evidence side, some of them have actually thoughtfully kind of said, we'll allow new evidence for good cause, and they define what good cause is, it wasn't previously available. Others let it all in, some let none of it in, and they review, an appellate record, and that's all. And so that was kind of what I was trying to get at. Maybe I feel a little bit more strongly about this than Matt. It's definitely, a key theme and feature of the report, though.
Well, I know. I mean, I'm in accord with Chris, and I think there are certainly on the specific question of de novo review, even if you're not talking about admitting or considering new evidence, it seems to me that there are any number of circumstances, any number of agency structures and purposes that would strongly counsel against de novo review, especially on factual findings.
Can I speak now?
Sure.
I thought there were two important points in the original 11 last time. And that was first that agencies should set their scope and standard review to be consistent with their specific objective of the appellate system as a general recommendation.
Mm-hmm.
And then, the next step is the question of, more specifically now, you should consider whether or not to use de novo review. And I think the idea of adding in there what Chris is saying, in light of the costs of time and resources, as a justification for the second two sentences as to why you might reconsider doing de novo review.
Thank you.
As to the first point, I would point out that we have in paragraph 1 as kind of the premier part of the recommendation that agencies should set the scope and standard review to be consistent with the objectives of the appellate system. So the first part that you had mentioned is actually elevated to paragraph 1.
The second sentence.
or the part about agencies setting their scope and standard of review to be consistent with the objectives of
Right.
their appellate system.
Right, right. Okay, so maybe the work that can be done in this paragraph can be a little more specific. The language I was thinking of, again, I'm trying to phrase this in a less damning way, would be something along the lines of agencies should consider whether de novo review is an appropriate appellate model, given that it can add case processing time or something to that effect. That would make it clear that if you opt to use de novo review, it can have an impact on your resources and your time. I think some of the issues that Chris has already flagged.
It also may, I don't know if this goes into the, I don't know if this falls under the rubric of time, but you're also potentially sort of misdirecting your attention to where it shouldn't be. If the purpose of your appellate system was to set policy,
Right.
or it was to provide definitive presidential interpretations, then you probably don't want to be reviewing factual findings on a de novo basis.
Thank you, Matt. I also think that language, but again, I'm just kind of, it's very rough language. It aligns closer to the similarly language that sentence should consider.
Nadine,
Gavin, why don't we strip out the in setting their scope and standard of review to be consistent language, since we've got that covered now. And maybe just start with agency should. And kind of go from there. Okay. Judge McCarthy, you had a comment?
No, I was just going to strongly agree with Matt's observation that agencies should not be considering de novo review for findings of fact. Should be substantial evidence, not only.
So just because I've got no pushback yet on my proposed language, what if we build that into that last line there that Gavin's put in brackets? Agencies should consider whether de novo review is with respect, maybe de novo review with respect to findings of fact is. Does that cover it?
I don't think they should be considering de novo review with respect to
At all.
findings at all.
Okay. So
Not at
so
all.
go back to
In
what it
my-
said. Okay. So delete that and go back to what it said is an appropriate model. So I guess really it's just a question of whether the committee is interested in saying, don't do this, or leaving it to the agencies to determine whether they should do it, given the reasons why we think it could be problematic, which I think is what we were trying to capture in the last part.
Well, I think the first sentence still suggests that there's a possibility for de novo review with respect to findings of fact. And correct me if I'm wrong, but I don't think agencies can review findings of fact de novo. It should be substantial evidence in the record.
Well, I have to disagree that the APA does provide for de novo review of facts by the review of the ALJ's decision, and whether agencies choose to use it or not is another question. But it's not that there's no. I mean, I think you should begin the sentence, the beginning, before agencies should consider. You should say, in light of the costs of time and resources, agencies should consider. Which tells why you reconsider what might be said to be the default APA rule. And so you say, well, there's a reason why you shouldn't use de novo because of these things, but I don't think you should preclude it.
Okay. I like that.
It might be nice to, I mean, time and costs or time and resources are part of the issue.
Okay.
Agency objectives is the broader issue in my mind.
Okay.
I could imagine de novo review being entirely appropriate in a small appellate level review where Congress and the agency decided they want every veteran or whoever, veteran's not a good example, but you could imagine something, right, where they actually want a trial de novo. That's not the general approach though, or it shouldn't be for most of these high volume adjudication systems.
I like that. Okay, so now we need to figure out the rest of it. I guess is the idea that the rest of it would stay? Thank you, Gavin. If you can make that bigger. I don't know. There we go. That's better. Okay. Is that the
Take out
way?
the quotation marks.
Yeah. Yeah, that's from the comment. In light of the objectives of the agency's appellate review or appellate system, and the costs of time and resources, agencies should consider adopting an appellate model where the standard of review is not de novo with. Okay. Anything further on that?
You might say instead of similarly, for similar reasons, many agencies should consider.
Anika, is that you?
Yeah, I was just going to say the very beginning of it, in light of the objectives of the agency's appellate system, I mean, I assume agencies are going to have varying objectives, and we've asked them to look closely at those. So I don't know what sort of the objectives means. We might consider saying something like consistent with the objectives of the agency's appellate system or something like that.
Okay.
I mean, there can be different objectives across agencies.
So now we need, yeah. Yep. Anything further? Thank you for that. All right, sold. Thank you, Chris, for proposing that comment. Okay, 12.
So I have to leave in a minute, but I just want to suggest adding the word high before quality.
Yes. Hear, hear.
And we can discard my comment there since we're not going to be addressing artificial intelligence at all.
Okay, great.
I have a comment on this just for the record, I guess. I don't think this recommendation, I think it's perfectly benign. I don't think 12 says a whole lot. That to suggest that a decision should be high quality, to me, doesn't say a whole lot. Walter Gellhorn used to talk about ACUS recommendations that said, "Thou shalt do good." I don't know what I'm not sure that this is worthwhile. I don't know. Maybe this is a question for Chris, whether we could say something or the committee should say something more specific about about decision making. I mean, one thing I suppose it could say is that agencies should be attentive to basically comments on judicial review about their decisions, but I'm not even sure about that. I just don't know what, saying high quality, I don't know what that means really. Of course they should be of high quality. But that's this one is the committee's call. I mean, I have my own views of, I think there are criticisms that can be brought to bear on the forms that decisions take, but I'd be a little bit uncomfortable making sort of cross-agency generalizations here.
Yeah,
I'm not
I'm
gonna
just, oh, sorry.
disagree. No, I was just going to say, I'm not going to disagree that this should be self-evident, but go ahead, Chris.
I mean, I think I agree with Matt. This wasn't a central focus of our interviews with the agency folks, although we did review decisions from each agency kind of after the fact. I mean, it has to be done. Some of them are really bad, but I think also Matt's point is there's also a really broad variety of appellate decisions from, they're very different. Each agency has a different approach. So I would be fine removing this. I'd also be fine keeping it. But I guess I just kind of flagged that. The more that Matt and I tried to kind of redraft this last week, it just seemed to seem less and less meaningful as we try to work on it.
Is there any benefit to retaining the last bit? So it would just be taking agency resources into account. Agencies should explore the use of decision templates. I mean, is that concept something worth retaining?
Well, when I'm looking at it, the things that I think are worth retaining, if anything, I'm not opposed to taking it out, but the things that jump out to me that may be worthwhile is plain language, readable, decision templates. So basically, I agree that, yes, of course, we all try to produce high quality work. But if we're going to say anything, I think that trying to make a decision readable, plain language, and the efficiencies of and the quality improving of decision templates, those are some new ideas that maybe agencies aren't already taking into consideration.
At the risk of, I think Roxanne's point's good, and one sort of, I think Chris agrees with me on this. One sort of generalization, and it might be too general of a generalization, but one generalization I think I can safely draw is that many agencies' opinions are just too long. I mean, I hate, just compared to their judicial counterparts or federal court counterparts, they're just too long. I mean, they're just impossible to slog through, and have way more many words than the issues warrant. And that's sort of a generalization I can sort of confidently make based on the decisions that I've reviewed across quite a number of agencies. I mean, I don't know where this leaves us. Maybe the word brevity can be put in. Maybe that's too general. Maybe that's not useful, but that's one generalization I feel very comfortable about drawing.
Can I just throw out some possible language?
Please.
So we can, taking agency resources into account, agencies should emphasize readability and plain language and explore the use of decision templates and other quality improving measures, period. And then maybe somebody can stick brevity in there somewhere and like get rid of the rest. So just see if there's any value to this and if there's anything we could do to make this worth having in.
I think that's great, Roxanne. I think we need to build in somewhere where we say appellate decisions. I'm not sure that it's clear what we're saying should be readable and plain language.
Good point.
Emphasize, yeah. Any thoughts on that proposed
We could
language?
throw the
Yeah.
word brevity in. How's that for editing? Throw it in. Throw in brevity
Or-
right after emphasize. So brevity, readability, plain language in their appellate decisions.
Any thoughts? Kent?
Just a quick one. I like the idea of brevity, but I might use the word concision instead. One thing I remember when clerking is, one problem we had is a lot of the immigration decisions were much too brief. They didn't actually address all of the issues that they needed to. So I wouldn't want to just say, just make it really short, because I don't think that's really fixing the issue either.
Concise, concision. Okay. Judge McCarthy?
Yeah, I was just gonna agree with Kent's word choice there, because the concern I have with brevity is the requirement that the fact finder address all of the relevant legal issues that are often in the procedural rules. But maybe when you get to the appellate level, much like the NLRB model, you can kind of, we agree with the judge except for the reasons set forth below. I kind of like that approach rather than going through the whole record again and just footnoting, where you might not agree with the ALJ or the initial adjudicator, and only addressing in a concise fashion what needs to be addressed. Just different models that I've worked in, and I like the NLRB model the best.
Judge Manuel, do you have a comment?
Yes, I'm not sure this is the place for it, but it sort of goes to the issue of brevity and cases and decisions written more concisely. And that's kind of the process or the procedure of summary judgment. But a lot of agencies take a record and where there really are no factual disputes, and we'll have a truncated decision and get rehashes factual matters that really are not in dispute. And as you know, the federal courts have really done a very good job of deciding cases summarily. And I think that's a process that could be utilized more with administrative agencies.
I agree. Judicial economy is always on our mind, at least. Does anybody have any thoughts on this language right here? I think this works really well. Thank you for everybody's suggestions. We went from non-addressing.
I don't remember if this should this Judge Manuel raises a good point. Should this recommendation sort of address summary dispositions? Certainly something that we addressed during our interviews.
Well, we could say other quality improving measures, comma, such as, I don't know if that's quality. Maybe that's more resources. Summary dispositions. Maybe that's a different issue.
You could add it after decision templates, use of decision templates, summary disposition, and other quality improving measures.
Yep. Anything further? Okay. 13, lucky number 13.
Matt, did you have something about this as well? Or do I remember incorrectly?
About what in particular, 13?
I had a note that you might have an additional suggestion on 13 as well, but I could be mistaken.
Well, I think you may be. I'm trying to remember what I might have said to you, Gavin. So I apologize.
No worries.
One comment here is that this issue was addressed in recommendation 2016-4, and maybe we could pull that up at some point. And I was just wanting to make sure that what was here is consistent with what's roughly consistent with what's in 2016-4. That was the Asimo recommendation, as some call it.
We can just flag, can we check that and flag that? I think the language and the concept is, yeah, you're already doing that, Gavin, great. Is fine.
I
Nadine,
agree.
one
Russell?
small thing.
Mm-hmm.
I wonder if we, where it says selecting and publishing, would it be helpful to add the word identifying? In other words, criteria for identifying, you know, what do you use to distinguish precedential from non-precedential? You select based upon criteria already established.
So you would put identifying in place of selecting or in addition?
I'd put it in before selecting,
Okay.
but it's a wording suggestion.
Uh-huh. Any thoughts on that?
I'm just now this discussion has refreshed my recollection. I don't think it's 2016-4. I think it was the source book that Michael Asimo wrote, and I believe in there he just said that agencies should have processes in place for designating decisions as precedential. So I just withdraw my comment.
Okay.
Nothing needs to be consistent with the source book, but in any event, I think it is.
Okay.
So Matt, this is Anika. 2016-4 does encourage, it says procedural regulations should allow and encourage agencies to designate decisions as presidential in order to improve decision consistency.
Now I'm wrong. Now I'm twice wrong.
So there's a little bit in there, but not much.
So that sounds consistent with this though, doesn't it, Anika?
It does, yeah.
Yeah. Thank you.
Okay. Anything further on this one? Judge McCarthy, I see you're unmuted.
I just have a question as to why we're limiting publication to the precedential opinions. Seems to be rather narrow when other recommendations encourage transparency and getting everything out there.
Well, I think, well, again, I can only speak to our experience. Our agency publishes pretty much all decisions, ALJ, non-precedential and precedential. So given that this is
publishing is a slippery word here in the website error. You know, some agencies have like official reporters, right? They're like, I don't think anybody looked at the paper, like the NLRB has a reporter, the MSPB has a reporter. Not all agencies do. If you put something up on a website, are you publishing it? I arguably.
posting. I mean, the reporter that's associated with our agency only can publish them because we give them to them. I mean, that was the old days. I'm talking about the old days before we had the internet. So,
I guess my comment was more to the point that they should publish all their decisions, all their opinions, whether it's precedential or not.
So you would take out precedential? So you would take out precedent?
Official opinions, yeah. I mean, I think it limits research. I mean, what if appellate court says this decision is not meant to be precedential, but one of the litigants wants to rely on it? I mean, I think we want the information out there so that people can take a contrary view, even if it's not precedential. But that's my view. So I think that's rather narrowing and encourages perhaps less transparency.
Do you want to say anything about what are the implications of labeling a decision non-presidential?
I think we have that. Do we have that later on, Gavin? Am I not remembering that right? I thought we had.
$17.
Both 15 and 17 make reference to precedential decisions.
Does it tell litigants you can't cite it? Is that what makes a non-precedential decision? Adjudicate. We
It was
won't.
23. I think it was 23, paragraph 23.
When posting, okay, yeah. Agencies should distinguish between presidential and non-presidential.
And explain the difference.
Explain the implication of a non-precedential decision, of labeling a decision non-presidential.
So when posting, agencies should clearly distinguish between them, should include a brief explanation of the difference, and you're saying also the impact.
Well, the implication or the, well, in plain words, what it means to label something non-precedential. Is it just a label it takes with it, or does it say the adjudicator is saying you can cite it, but we won't pay any attention to it? That's a pretty big difference.
Should the original paragraph we're talking about have a parenthetical clause that explains what a precedential decision is? I mean, the idea basically behind a precedential decision, as I would understand it, is that it's binding on the agency adjudicators in future cases. It's not that hard of a. I don't think the idea of a presidential opinion is very contested. The phrase published opinion is a slippery term, but precedential opinion, I don't know if Chris has any thoughts on this.
Not really. I thought published was similar to precedential, so I don't have any additional.
I mean, I just think published is kind of a term that's used in the federal courts very often, and it's got a lot of baggage associated with it. I don't think there's anything wrong with this, publishing precedential opinions. I don't think there's anything wrong with that phrase. The word precedential has to appear there. That's a key part of this recommendation, it seems to me, and designating opinions as precedential versus non-precedential is a very important question. I guess the issue I'm raising in response to Russell is, does the word precedential require some kind of definition embedded in the recommendation here?
That's the question I'm raising.
I see Jack is raising his hand.
Why doesn't the second sentence of number 23 take care of the concern about the consequences of a decision being non-precedential?
I think because it comes too late. I think 23 should be ahead of 13.
Well, 14, no, is it 14? I can't remember the number now. It's simply establishing criteria and processes for doing it.
So maybe the second sentence of 23 should be moved up into 14. I think the first sentence of 23 is about transparency, which belongs in the lower parts. But maybe that sentence at the end of 23 belongs up in that other one.
Mm-hmm.
You know, should explain the difference, and agencies should also include a brief explanation of the difference between precedential and non-precedential decisions.
But should this recommendation say what the difference is? I mean, isn't the difference pretty clear? Is there some question about what the difference is? And does the difference vary from agency to agency? It seems like a precedential opinion is one that's binding on all adjudicators system wide in the future. I don't know what else it means.
And the litigants.
Well, non-precedential are binding only on the litigants in the particular case, right?
Right. Well, I guess I'm just concerned that this particular paragraph is not about kind of what we tell the public. It's internal, isn't it? It's telling the agency to establish criteria and processes for what they're going to do later in terms of the posting.
Yeah, but I think it introduces problem. What is a precedential decision too early? I mean, I think I like Jeff's suggestion that you talk about posting them both, distinguishing between the two, and then say when you should establish clear criteria for processing and selecting and publishing precedential opinions. But that's my personal preference, because when I see the word precedential in 13, it jumps out at me, and it seems to suggest that you're not going to post the non-precedential decisions or publish
Okay.
them, and I don't learn that until 23.
Okay.
The
So,
other thing here on 13 is the question is the issue here is selecting precedential opinions, not publishing precedential opinions. I'm not sure what that means.
Doesn't mean much.
but
You
what
could
are we
take,
identifying and selecting the opinions for?
Well, to label them precedential or not. That's the
The key
point.
thing is precedential. I think that's just a fundamental issue in this in agency appellate systems is designating decisions as precedential.
I read that completely differently, Russell. I read it as telling the agency to establish how they're going to select and post. Not precedential, but just how they're going to select and post, what they
Okay.
post. So I think we have a problem if we're reading them differently. So we need to fix something here.
Well, I defer to you, Nadine. I really do. But to Matt's point, to say it's binding, that's a rather ambiguous phrase, though. Does that mean if it's not binding, a litigant can't even cite it as suggestive or illustrative?
They can cite it. We see it in our cases. They'll cite non-precedential decisions from the ALJs. They're trying to persuade, right? It's not binding. Maybe it's something that, the appellate body will find compelling and then make it precedent, included in their decision.
excuse me, but it seems like there's three ideas here. One is how are you going to, and what are the criteria for identifying which are your precedential opinions? The second is publishing opinions, whether precedential or not. And third is identifying to the public among the published opinions, which are precedential. Now, I'm with Matt. I don't even think you need to describe what it means to be a precedential opinion. I think that's pretty well understood by the lawyers who are going to be reading this. So I don't think you need to talk about what is, to explain in our recommendation the difference between precedential and non-precedential. But I think there's three different things you want to get across.
Well, one question that raises for me, Bill, is, but what about the question of, are there some agencies that prohibit you from citing non-presidential opinions completely, and then others that allow it? And so that there may be a difference. It may not be completely obvious in every case, the way Matt had described it.
Well, I mean, you're forbidden from citing something that's not precedential. How about a law review? I mean, can't you cite a law review article? It's not binding, right? Can you cite a non-precedential?
I can't think of a rule offhand, an agency rule that would prohibit citing a non-precedential decision.
So can I just ask, should this, if we're kind of heading in this direction, that this is how agencies will identify which decisions which appellate decisions, right? This is about appellate decisions, are precedential or not. So we wouldn't want to say opinions, right? At the end. Identifying and selecting appellate decisions as precedential and delete opinions. And I'm not sure that explaining the difference fits here. I don't think this precludes the possibility, it gives agencies flexibility to determine how they're going to do this. Russell, did you have something further?
No,
I think this is my own view is, I don't know what Chris thinks. I mean, if it were up to me, I'd go a lot further and encourage agencies to, draw the distinction and you make greater reliance on presidential opinions. But that's not where the committee is going to be. I think this is good, given this. I think this is pretty good, given where the committee seems to be on this.
I agree.
Okay. Anything further? All right, 14, oral argument and amicus participation. Now, there's a comment here.
Make clearer, clear.
I don't know what Chris has. My comment was whether this paragraph should go further and say something to the effect that agencies should make greater reliance on oral argument and amicus briefs under the following circumstances. Say when there's a policy issue that transcends the interests of the particular party, or situations in which the agency has chosen, to address a policy issue and it has a clear choice between rulemaking and adjudication and has chosen adjudication, and you may well want to hear from other perspectives since you've kind of otherwise foreclosed that by going down the adjudication route. And then I would say, and I'm not saying that all these things need to be listed, but you could also have situations in which an agency is relying heavily on an adjudication relies on legislative facts on a policy question. These are all related, and probably does want to at least wants briefs from non-parties. So that was sort of my question, was whether this should be expanded at all and indicate circumstances under which oral argument or amicus participation should be encouraged or explored.
Well, let's start with deleting clearer and just saying clear. I'm with Bill on that. Yeah. So would the next line say something like the criteria for such rules may include consideration of whether, I'm trying to think of what we would want to capture here if we want to make this a little more robust.
I would change the rule, the word for, clear rules for both to governing both.
Okay.
And then I'm not sure. I mean, I always have the question whether we're making recommendations of what they ought to do or just making recommendations of what they ought to consider.
Mm-hmm.
So I'm not sure if we need more.
Well, here we're saying, assess the value that it might bring to your system, right? And then just set the rules.
Right.
Does it help to add the language that Chris has here in the comment? So it would be in their appellate system based on identified objectives. So that grounds it a little more in considering yeah, I think it goes before the and after system, right? Chris, is that where you were envisioning it?
Yeah, just adding in based on the agency's identified objectives.
Right. So then okay. Maybe that kind of gets a little more teeth into it and a little more thought behind what the value might be. And we don't need the second part.
Well, I certainly thought that Matt's suggestion was a good one, that identifying the particular criteria that in fact agencies might consider as being
Okay.
justifying those things.
Give me some language, Bill.
I'm going to go
How
back
about-
to Matt for the language.
How about issues of high public interest?
Any other ones we can add?
Another one would be, I'm just to do something very simple, issues, I don't know, of concern beyond the parties to the case. I'm sort of struggling here.
Specialized or technical matters?
Anything else?
How about a novel or substantial question of law, policy, or discretion?
Can you repeat that?
A novel or substantial question of law, policy, or discretion. Which may be the same as high public interest. But I'm wondering, do agencies disclose this, or do they just say that we've taken a poll of our members or our commissioners, et cetera, and we've decided to grant oral argument? I don't know the answer to that, but I do know it with regard to some agencies. And I don't think currently that there's a disclosure of what criteria they rely on for the oral argument.
That's a good point, Judge McCarthy. I mean, that's a separate point here, but that's a good point. There are agency rules that I would say, this is impressionistic, but I would say the majority of agency rules, or maybe the vast majority of agency rules, do not provide, do not set forth any criteria for either, but rather just say sort of it's within the discretion of the agency. And I think what you suggest, my own opinion, is that it may be valuable.
Matt had originally added one that was involved a decision to decide a policy decision, policy matter on the basis of adjudication rather than rulemaking. I don't know how you phrase that, but I thought that was an important point.
I think to the extent, well, I was thinking of disclosure as being more relevant to our later section on transparency. I think this captures. Go ahead, Matt.
I was just going to say, I don't think of this as so much as disclosure as a matter of agencies thinking about when they want to grant argument and disclosing it in their procedural rules.
Well, to the extent we say establish clear rules governing both, is it clear what we mean there, that we're contemplating that they be part of, they would be published rules, codified, which we say earlier, right?
Bill, what do you think? You're sort of.
I agreed completely with your point that what we're really focusing on here is the agency actually thinking ahead of time what kind of criteria we're going to use and writing that down so that they will in fact use it. Whether that's rules that are going to be published for the world to know is sort of a separate issue on transparency, I suppose. But I agreed with you. What we're really focusing on here is the idea, when should you do this, and decide that ahead of time, not ad hoc as it comes up.
Renee, did you have something? I see you're unmuted.
Yes, I thank you. I wanted to suggest for everyone's consideration whether if the issue related to something that involves other agencies or other regulatory programs, that sort of transcended the particular agency that was, making the decision in some way, but maybe it's captured in some of these other criteria that people have listed, like high public interest or something, although it's not exactly that.
Issues of concern beyond the parties to the case, perhaps that one.
Yes. Yeah, maybe, yeah.
Okay.
Including other agencies or something. I don't know. Well, anyway, we don't have to say that.
Okay.
I'm sorry, can I return to the precedential thing for a second? Because it rang a bell with me. If you go back to number 2 in our list of all the things that ought to be promulgated and published, G is the procedures for designated decisions as precedential and legal effect of such designations. So we already covered that there. And I'm wondering whether we'd want to, and I hesitate only because we're going back into the past. The procedures and criteria. Would we want to include the procedures and criteria in what would be published there? And that really takes care of a lot of what we've been talking about. We have to, holistically, this thing is a lot broader than we're focusing in on particular things that maybe are left out of this first list. Would people agree with adding and criteria to that?
I would.
I like it. And then do we not need that paragraph later?
Can't you do the same thing with I when you're talking about oral argument?
I'm not sure how we would capture that. Russell.
Well, I was just going to add, when we were discussing paragraph 9, someone, I think perhaps Judge McCarthy, said rather than identify one of the screening or whatever term we want to use criteria there being the need for oral argument, it might be mentioned in what is now paragraph 14. I don't want to add more complications to the mix, but whether or not there should be any reference to that earlier point, which I think Judge McCarthy suggested be deferred to paragraph 14.
Renee, did you have something further?
No, sorry.
No, it's fine.
You might say agencies should consider including in their, I say screening criteria, whatever term you want to use, whether or not the matter is appropriate for oral argument.
So that would refer back. Yeah, I'm not quite sure that fits.
Well, I'm not sure it is either, but it was suggested earlier. It's better here than where it was before. I'm just raising it just to remind people that point was made earlier.
Perhaps it's captured by the language added above with, making it align with your identified objectives.
Might.
Yeah, I'm not sure. Can I just go back, since we added that language earlier, does 13 need to stay in? Is it repetitive?
It still seems to me that the what is in the long list of things that are supposed to be published, and now what we're talking about is the decision-making process about that which you will later publish. it's almost like this should come before what they publish in terms of, first you decide what you're going to do and then you publish it. That's why I said I agree with Matt that 13 is about identifying things ahead of time rather than doing it ad hoc. And the whole long list of things is what gets published in the Federal Register.
Okay.
And I don't think we should confuse the decision-making process about what should go in the Federal Register with just the identification of the things that should go in the Federal Register or Code of Federal Regulations.
Bill, I have to disagree with you somewhat on that, because I think the focus of 2 is also that they need to make these rules. They need to establish rules. That's the word promulgate. Publish is, I think publish was almost secondary in this. Matt can correct me if I'm wrong about that, but I think one of the big concerns is just that they don't even have rules about this. It's just sort of informally communicated practices and such.
I can accept that as a friendly amendment. My only question is that what we're talking about in 13 and 14 is what you should consider in making those rules, rather than the fact that you should make rules about these identified subjects.
Well, let's leave 13 in then. And 14, I think we can leave some of this for committee on style to kind of iron out, but I think we've captured the concepts that we want to include here.
I would agree. I think you could take out the clear rules because that's what would be in that list of number 2. And
Okay.
I think in number 2, where we talk about oral argument, we ought to add amicus participation, because I don't think it's there now.
So you would suggest, where is it? Would it be okay. Mm-hmm.
I can't see it on my screen, but it's below F. Yeah, right.
Okay.
Don't those seem like 2 totally different issues? Oral argument and oral presentation versus amicus? I mean, they seem completely separate.
Should it be a separate bullet? A separate?
Oh.
Can't you just use the disjunctive, the or, instead of the and?
I mean, the list does not need to be exhaustive, right? I mean, we're just saying, I need to go back, including, but not limited to. I think we can leave it as a separate if there's concern about combining the concepts. It's still there now.
Separate's fine.
Okay, let's get back down to, I think we're done with 14, and that takes us to the recommendations that we have not touched yet, right, Gavin?
Yeah, Nadine, I mean, if the comment is made that we should separate oral argument and amicus participation in the list, would that not also hold true for paragraph 14?
Well, this is assessing the value of both, and to the extent the concepts, yeah, I don't know.
It doesn't bother me as much here as it did over there, because they are just 2 separate things about that add value to a procedural system.
Okay. Okay.
Okay. So we're on 15.
I didn't understand the difference between a program adjudicator and a hearing level adjudicator.
Kent?
I think it's
I was
supposed to
just
say.
going to echo that. That was the one comment I had. I had to reread it to see if it was a defined term. So I might just say appellate program there, because it's trying to distinguish it from the hearing level.
I think that was the intent.
Fine.
I was focused on the word transmit. I wasn't sure what we were trying to say there, that make available, share.
Well, I think I could speak for Chris and me in saying that we talked to a number of appellate adjudicators or heads who talked about systems under which they transmit. I don't know what else. I don't know. Not sure what other word to use here. You know, they'll send a memo or they'll send an email or a bulletin or an alert. That's the concept behind this. Rather than letting people sort of be passive recipients of things and having to look up things on their websites, you actively push it out to the adjudicators.
The word communicate is the same meaning, I think, in that if people don't like, I like transmit, but communicate says the same thing, I think.
I think transmit's probably better there if that helps with the, I don't know. If it didn't bother anybody but me, that's fine.
If you change transmit, you'll have to change transmittals later in the sentence.
Well, I guess I had a question about that second sentence in terms of summaries. Now, obviously, that's when feasible. Summaries and explanatory materials. What sort of concepts you had in mind there? Typically, at least from my experience, the decision speaks for itself. So I'm not quite sure what summaries or explanatory materials are needed.
I would say that a hearing level adjudicator who got a sort of a 2-sentence explanation of what the precedent was would be a lot easier than having to read the decision. I think for the people, especially the hearing level people, anything you can make shorter and easier for them would be better.
I'd be curious, like, who's going to write those? Do they have to be approved by, you know, the decisions represent, at least at my agency, the votes of 3 presidential appointees. So anything extra beyond that, does it have to be approved by them as well?
I mean, when I was thinking of this, I was thinking of a staff prepared thing, and if it needs a disclaimer, like say a Supreme Court syllabus needs a disclaimer, I suppose it could have a disclaimer that it's a staff prepared document.
Explanatory material. I mean, I guess I was just trying to understand what would be contemplated here. Judge Manuel?
Yeah, how
Does
about
the
appeal?
head notes mean anything?
You have a certain amount of time to appeal, to ask for reconsideration, or just procedural explanations.
These are to the other adjudicators in the agency, right? They don't, not the parties. Russell, did you have something? I'm sorry, I think you were speaking.
No, not really.
Okay. Roxanne?
I guess I agree with Nadine. I'm not sure what explanatory materials means. I'd be fine if this sentence simply said appellate programs should include in their transmittal, when feasible, brief summaries of the decision.
Sounds pretty good to me.
Okay. Thanks, Roxanne. $16.
I was a little surprised by this. When I worked at the Department of Energy, it was the general counsel's job to do this. So I'm not exactly sure, you know, whether agency appellate system should be the only ones or should be anyone. that is
Well, would it be
responsible for this.
agencies should, or as opposed to the system itself?
Agency would be fine with me.
I mean, I think there's great value. We do that at my agency to know what comes past our agency. But I agree, there's some concern there about who's doing it, right? Anything on the question of acquiescence? I was curious about that line. I didn't know if Matt or Chris could speak to it. I think we're getting some static. Can everybody be sure they're on mute? Thank you. That line in terms of I was curious about that, what your report revealed, that was this a needed, I guess it was, if it's included. In what way is it needed to decide or alert other adjudicators in the agency how they should treat court decisions?
You know, this may be one that the committee wants to omit. I'm sort of curious to hear what Chris thinks on this. I mean, it is important at some agencies to know whether an adjudicator is expected to acquiesce in the decision or continue to follow the agency's precedents and other policies. It's a controversial issue, actually, at some places.
Yeah, that was my thought.
Seems like the second sentence is just an amplification of the first. And maybe the better, the discretion, we might want to use our discretion to omit that if we're just going to raise a can of worms with people.
That was my thought.
If anybody's on the fence here, just reminder that in 1989, ACUS had a project on acquiescence that was based on a consultant report by Ricky Revesz and Sam Estreicher, which yielded a great article in the Yale Law Journal. But I think the ACUS Assembly was unable to reach agreement on acquiescence policies and any other issue associated with it, and that's my recollection.
I would
My only
strike
thought
it.
on this, well, my only thought was to take out any policies and just, if the agency has decided that it will not acquiesce in this decision, then it ought to inform its adjudicators of that. Now, so if you took out of any policies governing, you can say notify adjudicators if the agency will not acquiesce.
Is the work in the first sentence to explain the significance of those decisions? Does some of that work get done in that phrase?
I think it could. This is just if you wanted to be more specific.
Yeah, I'm just concerned the minute we mention the word acquiesce, it could be. Roxanne?
I was just gonna say I like that latest edit that was just suggested, at least with regard to our agency. I think with regard to it being taken care of in the first sentence, I'd say no, because what happens for us is a court of appeals rules on something that the board decided. We get notified right away by one of the officers.
Uh-oh. Roxanne, we lost you.
Offices in the agencies telling us the decision was issued, but it might take quite a while before the board decides whether. And so then eventually the board will have to decide whether or not they will accept the court remand or whether they will file a cert petition, et cetera. So it's sort of two separate things, and there is a lag in time between the two determinations.
Judge McCarthy, did you have a point?
I would not mention the concept of acquiescence. I've read the article that Matt alluded to. I think it's for the agency heads to determine what they're going to do, and they shouldn't have to formulate a policy ahead of time. So I think it's very controversial, and you should leave it out.
And why doesn't the reformulation, which actually omits that, take care of your concern? Basically, it's the way it's reformulated. It just says they should only let people know if they're not going to acquiesce.
I would make one.
Why do you let them know that you're not going to acquiesce as opposed to when you? I mean, I think you're asking for an advisory opinion up front, and I don't think that's appropriate. I mean, I think the agency should tell the adjudicators, the public, and the Circuit Court of Appeals or the federal court in its formal decision whether it's going to acquiesce or not. But
Roxanne, did you have another point?
I was just going to make a change instead of in the decisions of the federal courts of appeals to say in a particular decision of a federal court of appeals. In other words, we're not generally going to non-acquiesce in all cases. It's at a particular decision. Now, that doesn't respond to the judge's point, I don't think, but and again, I don't feel strongly about this. I was just trying to make this language work within the context if you wanted to use non-acquiescence at all.
Roxanne, you froze. Did you have something further? I'm not hearing her. Okay. Any other thoughts on this?
The only other thought I have is on this is there's sort of two ways in which agencies can declare their position on non-acquiescence. One is in a future decision, NLRB style. Another would be the SSA approach, which would be to issue a policy statement on the question. Maybe this is anyway.
Well, I think we can leave it and keep our fingers crossed. Okay, let's move to 17. Decision making needs a hyphen. That's all I have.
When I read this, it occurred to me that, again, when I was in the Department of Energy, we didn't make the indexes or digest. The CCH did it and the question is, isn't that true of other agencies that there's private companies?
It's probably true of many agencies, but mine, we used to have 2 reporters, CCH being one of them, that would do this sort of thing, and not happening anymore. We're doing a lot of things internally this way, unfortunately.
I mean, could it be?
It should consider, I mean, it's a tool. We look at it as obviously a research tool.
Right.
And we
I mean,
staff
they're necessary. The only question is there some other way than making the agency appellate system do it? I mean, even whether it's, maybe again, it should be agencies rather than agency appellate systems.
Yeah, good catch.
And maybe even consider preparing or having prepared. In other words, allowing for outsourcing it.
Okay. Preparing or having prepared?
Yeah.
Any other thoughts on that one? 18?
Oh, actually, can we stay with 17 for a minute?
Renee? Yeah, Renee.
Yeah.
One quick one.
Go ahead, Renee.
Yeah, it's that what is those decisions? What is the what is those referring to?
Precedential decisions.
Those decisions on position consider just identify. Okay. Well, I mean, I guess, yeah. All right, I see what you're saying now. Okay, never mind. I had in my mind a more general concept.
Right.
So I thought maybe it should say relevant decisions, but now I see what you're saying. So maybe that's fine. Okay, thanks.
Yeah. 18. We have a comment about adding precedential. before
Nadine,
case.
very quickly.
Yes, Russell. Yeah. Go ahead, Russell.
On 17, to help adjudicators identify those decisions, the implication is this is not going to be a published document. Is that right? The only people who have access to it are within the agency? And does that need to be made
Right.
clear?
I mean, I think Bill's point is there
I
used
think
to
a lot of
be,
lawyers would be interested in having that digest.
well, there used to be, reporters and publishers out there that
Just
would do that.
whether it skirts over an important. We've been talking a lot about transparency. My only question is whether or not we want to leave the implication this is if it's agency prepared, it's available only to the agency. It's not a big point, but people are going to ask.
Well, I mean, some of it is, in some limited fashion externally available, usually for a fee. But to the extent that agencies have internal resources that they've cobbled together or somehow, yeah, I guess the question would be, is it foiable? One, is it, if it's not, is it something you would want to disclose anyways? I mean, we've run into issues. I mean, obviously, if there's publishers or reporters out there that have these materials, then they're copyrighted. And so to the extent that you have something internal that's a cheat sheet of some sort, not sure that it would be releasable.
Well, it's just a question of whether you want to say to help adjudicators or just say to help adjudicators and others identify those decisions. It's the adjudicator sets up right away the flag. This is available only internally. Okay.
Any comments on that?
I mean, why can't we just say to help identify those decisions and their significance, and then leave out who we're identifying it for?
That works for
I think
me.
it's a good idea.
Yeah. Great. Okay. 18.
In the second sentence, I was a little put off by the congressional liaisons in the sense that the appellate system would be communicating directly with the congressional liaison rather than through somebody else in the agency. I thought addressing with agency policymakers would be the right place to have the appellate programs talking rather than directly to the congressional liaison.
I just had a, I was just.
I have a question.
Yeah, Russell.
I'm wondering and Matt, maybe if Matt would want to answer, I wonder if this relates to this project that ACUS established somewhat on the suggestion of Judge Katzman, that it communicate occasionally to Congress agency decisions that Congress may want to take a look at. And whether or not this is a reflection of that program or not, or whether or not it's something more systematic.
I actually hadn't thought about the Katzman-Wheeler project, as it's sometimes called. it's a good point.
Well, what caught my eye was the reference to any needed statutory amendments, because in the former project, we were very careful not to say to Congress anything you need, here's an amendment for you to consider. That would get Congress's ire. All we said was, this is a decision that may be of interest to the Congress, and let the legislative staff figure out what the ambiguity is that they need to worry about. I mean, it was very touchy, and when you're dealing with courts of appeals, it may not be so much here, but there may be some language, some references in there that need to be made clearer.
I was just
I
also
think
going to
ACAS
flag.
does still have that program, though, does it not, Matt? You're still
Does who
doing
have
it?
that program?
We do.
Yeah. Oh, ACAS. Yeah, ACAS does have that program. I mean, I sort of think of this as something of a different issue. ACAS is a little bit less cautious than the judiciary, but no, we don't recommend statutory amendments. But an agency certainly could when communicating with Congress. I mean, this is an area on which Chris has, a lot of expertise, having written a report about agency legislative communications. But they're common fare, these kind of communications.
Okay.
I just didn't know if we wanted to just account for the fact that at least, I see Judge McCarthy's back. At least I think at least our two agencies where there's split enforcement model, this just doesn't happen for us. It's just not even an option. If we wanted to leave it broad, obviously it either you take it or you leave it.
The word congressional liaisons could come out here. I mean, you've got other appropriate officials. That doesn't address your particular concern, Nadine.
No, that's okay. Anything further on this one? My only thought was whether it would work to say as appropriate, but maybe that's implicit.
I don't know if Nate, is Renee, are we waiting on Renee or no? I think a qualifying phrase is fine. I don't see any problem with it.
I was actually, well, I mean, now we have a couple as appropriates. I mean, the whole, all of it.
Where did you mean?
At the outset, sorry. As appropriate, agency appellate system should regularly communicate. At the very top, yeah. I mean, and I fully recognize that we are probably more of an exception than a rule.
Did you consider the point that was raised in the comment about adding presidential here? And was everybody okay with that?
I thought that made good sense. I mean, I wondered have we been saying precedential decisions? The case-by-case adjudication, is that new phrasing? Or maybe that's something committee on style can look at. Okay, anything else on that one? Tom, did you have something?
Nadine, what was your concern? I'm sorry I stepped away for a minute, but I mean, aren't we getting dangerously close to ex parte communication type issues here and conflicts of interest? I mean, why? I can't imagine going there, kind of like you said, but I mean, it strikes me that it's fraught with danger to reach out about how you're going to address precedential decisions, whether by rule or case-by-case adjudication ahead of time. I mean, I think you need to reserve that to the political appointees or the heads of the agencies who are going to make the call.
Yeah, my concern was simply that this is just not something we would do at our agency, you know, and I think you as well with the split enforcement model that we're part of. We're purely the adjudication side, and we're not at all interacting with rule writers or policymakers.
I think you're anomalous though, Nadine, the split enforcement. There just aren't very many of them. I think of this as a very critical function at a lot of agencies, and one where there's where agencies could probably do a lot better. There are certainly agencies where it's very common for the appellate, for the adjudication programs to regularly communicate with policymakers on the content of rules and so forth and so on. That's where the expertise resides.
Any other thoughts on this? Bill, are you
I agree with
unmuted?
Matt. I agree with Matt.
And, you know, it's not inconsistent with a judicial model because it goes on all the time in the federal courts. That's why there's a judicial conference in the United States to set policy.
Okay.
If I could just comment. Yeah,
Yes.
I get the point. I think it's true that judges may have useful input into the rulemaking process. At our agency, our group is called Regs and Legs, and they're the ones who advise on those issues. But I agree with Judge McCarthy in the sense there's something troublesome about judges adjudicating and also making the law. So should judges really be helping to promulgate the rules and then also adjudicating those rules? So there is reason to be cautious here, and probably it's not that there should be no interaction, but I think you could cross a line there where the judges are making suggestions that could pose a potential conflict of interest.
Let's say I'm you'll probably enjoy this example, Roxanne. I'm an NLRB member, and I want to decide that we're going to address everything by rule instead of case-by-case adjudication. And I go hard and I lobby hard to Congress and other policy officials to change the existing system. I don't think they should be involved in determining whether the decision should be addressed by rule or by case-by-case adjudication. That's perilous to me.
But Judge McCarthy, at the NLRB, the appellate adjudicators are the members of the board. And this is exactly what the board has been doing of late, is deciding whether to address something by rule. If you see recurring fact patterns, recurring issues, you might decide that this issue is best addressed by rule. I don't know why that's inconsistent with the role of an NLRB member.
If that's their independent judgment, and you know their ideology, I think that's great. The fact that they're interacting with other folks on the Hill, they're presidential appointees. They want to interact with the White House, that's fine. But they're interacting with congressional liaisons and others. I think that is rife with potential for conflict and improper communication as to how they're going to decide the case.
But it's not referring to specific cases. It's not referring to the adjudication of specific cases.
But it is referring to how you're going to address what you've decided in an interpretation or policy in a major decision subsequently, whether by rule or by case-by-case adjudication. I just would never go there. So, but
I mean, this could be qualified, but it seems to me like a complete abdication of responsibility if the members of the NLRB aren't considering whether to address a policy matter by or any other or a lot of other agencies by rule versus adjudication. This is what agencies do.
And I would add that this is true even for something like the Environmental Appeals Board. I mean, there's absolutely nothing inconsistent with them saying, hey, we're getting all these different cases bringing the same issue. This would be a lot better decided by the agency by rule. They're not deciding anything improper in the case before them. They're advising there's a problem.
Can we capture some of this discussion in this language? I mean, one thought would be to say, first of all, would be to take out regularly, maybe that, just, we don't need to quantify it, just communicate. And then to address whether recurring, I mean, I'm hearing kind of this common thought that recurring issues in their decisions be addressed by rule.
You could also, to address Judge McCarthy's concern, there could be a qualifying sentence that says that in the context of a particular case, they shouldn't be having discussions with policymakers. That's a different matter.
Well, my concern was the congressional liaisons, and now that that's out, I mean, I have less of a concern. They want to interact with the White House and, OMB and things like that, but they shouldn't be going on the Hill and talking about how they're going to decide cases and then be in a position where they could exchange that for a statutory amendment.
Tom, this brings up a really interesting issue about how much agency heads should be explicit about their policies. When the Attorney General started deciding immigration cases in order to push his policies for the Justice Department, I actually thought that was completely appropriate because he was the head of that agency. And I think the same thing, I don't think there's anything wrong with the NLRB members telling anyone what their view on legal issues is, and saying we're considering a rulemaking or whatever. I think that that's part of the job of an agency head. They're in a much different position with regard to that sort of prejudgment than ALJs and people on appellate boards that aren't at the top of the agency.
Judge Manuel.
Yeah, NLRB, they are serve an adjudicative role also, and so they're sort of in a different boat. But take the example that Jack just brought up, the Department of Justice. Certainly the Attorney General can promulgate rules. That's one thing, but typically you would not have the immigration judges up there involved in the process of promulgating rules. So there is a distinction there between the adjudicative role versus the actions of the agency. So if that could be alluded to in some way here, I think it would be helpful.
Well, at the Bureau of Immigration Affairs, the Board of Immigration Appeals should be able to talk to the Attorney General about needed changes to the system. I mean, that's what this is addressing.
Should they be able to go on Capitol Hill?
Nothing here suggests going to Capitol Hill. Congressional liaisons was referring to agency congressional liaison. That's people in the agency. We've taken that out anyway. So I mean, the idea of talking to Congress is not in this at all.
Well, that's what I'm saying. The congressional liaisons. I think that's a separate office typically. My point is, I think it's prudent to have some distinction, some separation between the adjudicative function, even though they are administrative judges within the agency, and having the agency interact and to promulgate rules.
But what's wrong with say like Jeremy, the Social Security Appeals Council? They should be communicating about identifying issues that might be best addressed for efficiency and other reasons might best be addressed by rule. That has nothing to do with putting the thumb on the scale in a particular case.
Yeah, I mean, a significant objective of certain appellate systems is ferreting out interdecisional inconsistencies and saying maybe we need a rule on this point to actually to improve decisional consistency in this case. It's not necessarily saying here's how you should resolve it, but we are noticing that judges are deciding cases differently. Maybe a rule would improve this.
Yeah, I think that's the point, is that it's what the communication is. It's whether it's suggestive in nature, whether it's, it's the way, I think putting up a cautionary flag there, letting people know that that should be carefully done would be useful.
I don't know if you can hear me. This is
Yes.
Roxanne.
Yes.
Sorry, I've been having trouble with phone connection here or whatever. I would just say that for the NLRB, obviously they do rulemaking sometimes and often usually do case by case adjudication, but where they draw the line is they don't get involved with any statutory amendments and are very careful not to comment on pending legislation. And so they don't want to, so they're happy to rule on a case. They're happy to decide when a particular issue is better off being subject to rulemaking, but they don't try to change.
Okay.
Well, you could nix this, the committee could nix this last sentence if that's really the issue. If it's statutory amendments, I don't know what Chris thinks. To me, the bigger issue is the rule versus the need for rules.
I would support striking the second sentence.
Me too. I mean, I think the statutory amendments brings in the possibility of quid pro quo and the untoward nature of that type of relationship. And I think
we don't want to go there. Okay, let's strike that. What about the language that's there now? Hearing no objection. I think we're good. All right, 19 is so controversial. I just don't even know what we're going to do with this one. I'm being sarcastic. I'm getting punchy at this point. I don't have anything on 19. Anybody have any comments on 19? Great.
My only comment that this is not a throwaway recommendation, as Nadine well knows, as the co-chair of the Adjudication Council, agencies are thirsty to share information with each other. Really thirsty.
Absolutely. Absolutely.
And Jeremy knows well too.
Okay, disclosure and transparency. I see some light at the end of the tunnel. Of course, we still have the preamble. So disclosure and transparency. 20.
I had a general question about this area, which is so much of what we've said already, especially in 1 and 2, have been about publishing things. That should number 20 be agencies should, in addition to the matters specified in other recommendations or other elsewhere in this recommendation, agencies should adopt the following practices, and then have this be A, B, C, and D. Because that, I think we got a little boxed up on this earlier in this meeting when we were forgetting that we had talked so much about publishing things in the earlier ones. Something like that.
I think the distinction in the earlier ones is actually codifying in the federal rules, in the Code of Federal Regulations as rules. So this would be more disclosure on websites. So once those rules are established, are you making them easily, readily available and easy to find on your website? Now this 20 is maybe a little different animal to the extent that this is about delegating review authority. I assume that this contemplates these are rules that would already have been promulgated and published. I don't know.
Sometimes these are, I think what inspired this in part is sometimes these delegations are hard to find.
And I don't think, do we talk about delegations, just to reference Jack's point back at the beginning? I don't see it. Okay.
No.
So I think we need to keep at least, I didn't have any concerns with 20. Does anybody have any line item? Bill?
My suggestion would be any rules and statutes authorizing such rules.
Okay. All right, let's go to 21, which deals with video, live streaming. So there's a comment to delete the Sunshine Act reference. I would prefer to retain it, but obviously committee discussion. No discussion? All right. '22? So this goes to process in terms of how internal processes work. I don't think that this is contemplated in that first section because I don't think that these are necessarily rules that would be published in the CFR, but that they may be, right, internal processes. I think this is what, if I'm recalling this correctly. Matt, Chris, any comments on that?
The first the parenthetical phrase, that subject could be addressed in a procedural rule, like the assignment of cases to panels and the authorization for that. The other thing, role of staff, the order in which cases are decided, not generally addressed in procedural rules. And a lot of black box situations here where it's very opaque in terms of what agency's doing. Some agencies are actually very good here. I think SSA is pretty good, Jeremy, wouldn't you say? The Alex man is pretty good on that front.
Yeah, says a lot.
Any concern with adding the process of? I think that works.
Then I think you would change assignment of to assigning. Process of assigning cases to adjudicators. And then is programs have to be possessive with an apostrophe S?
Good catch. Is there any, I think role of staff is fine. I was going to say, is there any benefit to kind of teasing that out a little bit, but I think it's probably clear what we mean there. The order in which cases are decided. The only comment I had about the order in which cases are decided, some of that, at least at my agency, is typically covered by budget documents and strategic plans that we were required to establish that kind of set out case priorities and case processing times and goals. Not necessarily in a rule, but obviously posted on our website already. So. Okay, 23. This was the one that we briefly visited earlier.
You gonna go somewhere? Okay.
I want to go for a walk too, Bill. That sounds great. Anything on this one? It's fine. Russell.
What seems to me, explanation of the difference is pretty vague. Is that still what it says? A brief explanation of the difference? Difference as to what Matt said before? I mean, what precedential and non-precedential means, or difference in terms of citability or just, if I were reading this recommendation, I'd wonder what
Mhm.
the context of difference is.
Do you have some language that you would include? So should include a brief.
Well, we discussed this before and it got rather complicated. Of the brief explanation for practitioners of the difference, something like that. I mean, just give an idea of what we mean by it.
In terms of their binding nature.
Something like that. Whether, and somebody said before, whether or not they are citable.
Well, I think that the issue of citable was resolved, that there's no such thing as a non-citable
Okay.
opinion. You know, what I was thinking of was that the Federal Circuit used to prohibit the citation of non-presidential Federal Circuit opinions, and I think that got made illegal. There was a rule issued that no court could prohibit citation of non-presidential opinions.
Right.
But you know, it's to me that explanation of the difference, because there could be all kinds of differences, and I don't think we need to add anything. It seemed to me there could be, like, how we're going to codify them could be, you know, how we're going to publish them could be different, how they're going to be, anything, you know. I just think it's fine leaving it vague like this. It covers the whole gambit.
Singular difference or differences? Or is that just nitpicking?
I think singular, their difference. I mean, it's their different nature, right?
That's fine.
And in the first sentence, should it be websites when posting decisions on their websites? And then do we really need clearly in after that?
I don't think so.
Yeah.
So does it need to be their difference? Does that work, Russell?
If it's singular, it should be the difference.
Yeah. Do we want to add any language here to the second sentence? Jack is saying no.
No, I recede.
Renee?
No, I agree.
For the same reason that singular works well in the second sentence, it also works well with websites, but I'm not going to push on that one because I know there's a disagreement on that. My grammar says to leave it singular there, but.
Well, I think the two things are different. So, yeah.
I'll say when posting decisions, agency website should clearly distinguish. That solves that problem.
Much better. I'm not aware of any agencies that have more than one website, but I could be wrong.
So when posting decisions, comma, agency websites, no.
Website should
agency website should not clearly.
Should distinguish.
Yeah.
Agency websites should distinguish.
The websites aren't acting at all. I would leave it the way it is. It's the agencies that are doing the action, not the websites.
Oh, we are getting punchy now. Okay. We're going to leave it. We have to leave something for them to fuss over at the plenary, so we'll leave it. All right. 24. Websites, yes. $25.
There's another websites.
So we have a suggestion to add the notion of soliciting suggestions for rules changes happy to say we do this. Any comments on that?
I think I think my personal opinion is that it's a good idea, and I think that's actually in accord with 2016-4.
Great. Judge Manuel, I see you're unmuted.
Yeah, is the, on paragraph 24, the first line, should consider as much as practicable, or am I reading that wrong?
Yeah, I'm not sure. I started to think to the extent practicable, but we can leave that for committee on style to sort out. Gavin, your good
Thank you.
judgment.
The issue
Thank
is that as it's written now, it's how much they should consider it, not how much they should do it. In other words, they should consider as much as practicable, not they should include as much as practicable. So it's not written. I'm assuming that the latter is the real intention of the meeting. So it's not written. The clauses are out of order.
Okay. Anything further on 25?
Yes, I certainly agree with the substance of what that added sentence does, but I don't understand what it has to do with number 25.
Oh, okay. You think it's out of place?
Yeah, and it says generally soliciting suggestion for rule changes. I mean, it just doesn't seem to have much to do with this whole recommendation about adjudicatory appellate systems.
Out of place? Anybody? Matt or Reeve, somebody might remember whether it's feeling vaguely familiar that we've said it in another recommendation.
It's in the APA that they have to have a process for doing it, but whether they have to put it on their website, I don't know.
There's Reeve, I'll turn this over to you with the following comment first. One is we do have a recommendation on petitions for rulemaking. Two, 2016-4, I believe, says that agencies should solicit feedback. I don't even think it's limited to rules, but more generally, the way their programs operate.
Yeah, I don't really have anything to add. That sounds exactly right to me with respect to what 2016-4 says. I think it's an important point to capture. I take Bill's point as it plays that in context, but I think it's a worthwhile thing to include. It would be in accord with that past recommendation.
And I will say just this empirically, while some agency sort of appellate sites do solicit feedback, many of them don't.
So perhaps it should be a separate, let's make it 26 and let's see if we go broader here, it's not just about rules.
But at the same time, more narrow, it's about appellate systems. So you affirmatively solicit input for changes to its appellate systems. I mean, that ties it back to this general feedback's great.
Seek, welcome, encourage feedback.
Agencies should affirmatively solicit feedback on their appellate systems. Should affirmatively, on their webs. Agencies should on their websites affirmatively solicit feedback concerning their appellate system.
That's what 16.4 says. And by the way, Nadine, you're like 4 recommendations short of the number in 2016-4. So I don't know if you want to add 4 more or something like that.
We could split them up.
Can I just revisit? I just on note 25. Can we take the word any between remove and material out? Just for my grammar thing is bothering me. No, the other one.
The other one.
The one right below it.
Yeah.
Anything further? Can we move to preamble? Yeah, I think websites, I'm sorry, agencies on their websites. Is that what you said, Jack? Should affirmatively solicit. No, I can't remember the order you suggested. Jack? Yes, no, he's not listening.
That's what
All
he
right.
suggested.
Thank
I
you,
would
Bill.
change the second on to concerning. That's all I was saying. I was talking, but I was muted.
That's all right.
That's the new version of forgetting to attach the attachment.
Could we say solicit feedback concerning their appellate systems? That just seems it's concerning the operation of their appellate systems. I don't know. It just seems so amorphous. And don't we really mean, or the functioning of their appellate systems? Isn't that what we mean?
That's a very friendly amendment.
Anything further? All right, we're going to the preamble. We have limited time, but we do have time. I'm just going to say, and I really am not saying it only because we have limited time, but I thought the preamble was very well done and hit all the right marks. So rather than go line by line, let's start paragraphs. First paragraph. Second paragraph. Third. Fourth, fifth, sixth. We only have 6, right? 6 paragraphs?
Yeah.
I'm just gonna open it up. Just shoot out a line if you have something. If you don't, continue to remain silent and that'll be great. Awesome. Anything.
What happened to Jack?
He had his thumbs up. I think he likes it.
Okay.
This is a great preamble. This is like the preamble that ought to be the model for all preambles.
I'm right there with you, Jack. I thought the same thing. It was very well done. Anything. Okay. Wow. Could that be it? Are we ready for a vote? Am I getting ahead of myself, Gavin? What am I forgetting?
I don't think you are.
Wonderful. Okay, so voting. For voting members only, right? If you are not a member, no vote for you. I guess any objections? I will assume it's a yay. We can do thumbs up. We can do an affirmative voice. Yes. Do we want to go through the list? Russell, yes.
Yes, for me, yeah. Or just ask for any no's.
Renee?
Yeah, no, I'm fine. Yes.
Jack? I'm looking at my list here. Who am I? Come on, Gavin, help me out here. Jack?
I can call the roll. Jack Bierman?
Yes, there's no voting function on this GoToMeeting?
I don't believe so.
I haven't looked, so we can do voice. It's good. We have a small group. Russell, yes. Jack is a
Yes.
yes. Tom?
Yes.
Anika?
Yes.
Roxanne? She's a yes. She says in her chat. Excellent. Judge Manuel, are you're a member? Yes.
Yes.
Janice Hoffman?
I'm a yes.
Right.
Who else that I'm missing?
Michael Cole?
Oh, I'm sorry,
I'm a-
Michael.
Yes. Yes.
Thank you.
Are there any other voting members of the committee that we did not call?
Me and Kim Barnett, yes.
I'm sorry.
Apologies.
Okay,
Well,
excellent. Excellent, thank you. I was watching the clock and concerned, but I knew the preamble was stellar, so I was hopeful everybody agreed, and they clearly did. Excellent. Okay, great. So that wraps up our fourth meeting. Everyone who has participated, I am extremely grateful for your time and your immense talents in getting this across the line. I will look forward to seeing you all virtually at the plenary. And thanks to the conference staff, thanks to our stellar consultants, Matt and Chris. And
And we
who am
thank
I
you also, we ought to thank you too, Nadine. I don't know by what mechanism, but anyway, I offer my personal thanks to you. And I think I can speak for everyone in offering the committee's thanks to you. You've carried a very heavy load this fall, or maybe you always carry a heavy load for us, but you always discharge your obligations very ably, to say the least. And thank you so much.
Thank you. Thank you. Well, the staff makes that an easy load to bear. So I look forward to the plenary. We'll get these both out the door. I'm looking forward to the first virtual plenary.
Well,
And
you should speak for yourself.
I look forward to seeing you all there and getting these two across the line. Thank you. Have a great week and a good holiday ahead, virtually as well. Safe. Take care. Thank you.
Thank you.
Thank you, Nadine.
Thank you.
Happy
Take care.
Thanksgiving.